Thank you for bearing with me with a few technical difficulties and our late start. My name is Carolyn Buys, and I'm with Goodwill and Trust Estate Planning Law, and I'm pleased to welcome you to our webinar today focused on Guardian Nomination Workshop. Before we get into it, I wanted to present a few housekeeping items. First, the chat feature is open. It comes directly to me. So all of your messages, if you have any questions during the presentation today, please feel free at any time, as soon as they come to your mind, to jot them down. I may not get to them until at the end, but I will answer all questions you have. And they'll be private just to me. Towards the end, if anybody would prefer to speak, there's an option to raise your hand and you can ask your question if it's something a little bit more in detail. As I said, I'm very excited to present this to you today because as my role as an estate planning attorney, the most common questions I get are around how to choose guardians for our children. And so I've created this workshop to help people understand a good framework and a process for making those decisions. In fact, it's a homework assignment I send home with my own clients when they're working through this process, when they're having troubles and struggling with it. And so that's what I'm going to provide for you today. Don't worry about taking too many notes. Towards the end, I'm going to share with you some documents that will have all the tips and all the things I talk about that are important here on the slideshow today for you to take away and home. I'm not going to share it quite yet because I want you to engage with me in the content before us. That will also include 3 different templates that you can use on your own to nominate guardians in a legally sound way. So best way to learn today, go ahead and turn off that phone, close your door. You deserve this time for yourself. And at the end of this session, I'm also going to offer anyone who's attended this session with me is a complimentary one-on-one meeting, a consultation, so we can talk about you and the people you love the most and how you can protect them. So a free consultation for getting yourself what I call upskilled in a little bit of estate planning and legal jargon and approach allows me to take some time with you in a one-on-one situation and give you a little bit more tailored advice about what would work best for your family. How did I come to this area of law? So I've been an attorney practicing in Oregon for over 15 years now, but I've transitioned into estate planning law because I feel it is so important to help parents and families plan for the worst, but also expect and hope for the best. It is an important tool for proactive planning and preventing so that we can spend more time living with our families, enjoying our families, loving our families, because we know if something should happen, there's a plan in place that we don't have to worry about it. And our family and friends and loved ones can take our instructions and move on and do the best that they can, just as we would do for our children if they were here. So if we were here. So what we're going to talk about today, I wanted to give you a little bit of our workshop agenda. First, why is it important to legally name guardians? And I also want to start, before we get into the process, with a couple of disclaimers about what it can and cannot do, because I often get some very pointed questions right up front, and I want to set the tone for what legal guardianship really means in this context and what we have powers to do and what we may not have always powers to control. Then we'll dive into the process, how to legally name guardians. So we'll go through the process to determine who. And we'll try to go through a process that touches both our hearts, but mostly our minds and our reasons as we rationalize this process. I'll show you a little bit about the documents around how you can document your decision for yourself and what that means, what that takes, and provide you some templates to do that with. As we go through that process, I'm going to call out steps along the way of the 6 mistakes parents most often make when thinking about naming guardians. And then towards the end, I'll talk about the 9 steps to make sure that these documents are going to work when you need to. So it's not just about documents. You hear me say that a lot when I work with my clients in estate planning. The documents are a very small piece. It's not called estate documents. It's called estate planning because it requires a whole planning process around that. And finally, I'll just give you an overview about thinking about next steps. And as I said, my gift to you for attending this, a chance to have a consultation session with me. So at the end of this, you'll have your free takeaways of choosing and naming guardians, both a process tip sheet and the template forms. So who will care for your children? Have you thought about this? I know this is a tough question that all parents face. And the most important thing is that who would you choose if you were the judge? Probably a lot of us have had somewhere within our families or our friends some story of a guardianship situation. In my own family, I didn't have to go to that route, but my parents were older when they had me, and there was a 17-year difference between myself as the youngest and my oldest sister, 17 years. And I remember stumbling across when I was nosing through the drawers in my parents' room as a kid, coming across their will and noting that they drew it up when I was about 3 years old. So my sister would have been 20 years old. And they had nominated her to be my legal guardian should anything happen to them. And if they had not done that, I thought about what would have happened because at that point, my father's sister was still alive and had 4 kids of her own and raised them. And she would have been a logical choice to raise me as opposed to a 20-year-old woman. Now, my sister at 20 years old, she would have done a fantastic job. She was always very mature and things like that. But if you had to go and put those people in front of a judge, what would the judge decide? On paper, they may have gone with my Aunt Estelle. And what was not known at that time, and what wasn't really discussed in polite company, shall we say, was that her husband had a history of domestic violence. And my parents knew that. Now, that was never documented. There were no police reports, right? But that's why my parents decided a 20-year-old woman who was much more mature was going to be better for me than my Aunt Estelle and her family situation. But if that had to go before a judge and had to have that battle out, the person might not have chosen my sister, as my parents knew best what would have been the best situation for me. So we know it's hard to talk about. We know it's a difficult situation, but you're taking the first step of putting into writing what's already in your heart. So let's go through the sort of frequently asked questions first. So do my guardian documents keep my family out of court entirely? That's the first question. No, guardianship always requires court approval. But telling your family what you want ahead of time is the best way to preserve your wishes. Because what happens is if your wishes are known, one of the best things families want to do in memory of their lost loved ones is to honor their wishes and to respect them. So if you set out a plan, 9 times out of 10, a family is going to respect that. My mother, by the time she was 12 years old, had lost both her mother and her father. And at that point, there was a battle between her mother's family, her aunts, and her grandparents on her father's side as to who was going to raise these children. Now, my grandfather's family was from upstate New York. My mother and her immediate family lived in Boston area, which was much closer to where my her maternal relatives were. And so eventually it was decided that she would stay with her mother's family. But what that did was that battle divided those families apart. And my mother never, ever knew her paternal grandparents or her paternal side family ever again. They lost touch because of that rift, and that was unfortunate. So you will still have to go to court, but the idea is that you're giving guidance to your family as to what you want to do. Frequently asked question number 2. I am divorced with sole custody. How can I make sure my ex doesn't get custody if something happens to me? Now, that's a tough one. Legal and physical custody don't necessarily terminate parental rights. There are no guarantees, but if you document your wishes, that's the best step you can take for helping those people that you want to take guardianship of your children. The tools, the arguments, the evidence as to why that person might not be the best guardian for your children moving forward. And we'll talk about that later on as one of the templates, a confidential exclusion of guardians. Again, none of this stuff guarantees, but I can guarantee you what doesn't guarantee you is not putting anything down on paper, right? No documents whatsoever means that there's going to be fights. There can be fights, there can be battles, and there's a lot more left open than if you are clear about your wishes. And as we'll talk about later too, expressing them, discussing them, communicating them is a huge part of your plan. Frequently asked question number 3. If something happens to me first, how can I guarantee my spouse or other parent doesn't change our choice? The last question was for those who are separated. I see this question a lot with couples who are together and who may have some disagreements around who are the best guardians for their children. And how do they kind of preserve the choice that they agreed upon while they're when they're both alive, when one of them should pass. Again, no guarantees. Your documents are just part of your plan. It requires communication, collaboration, and a recognition that control and circumstances can change. Maybe your spouse is going to make a change because something has happened. Maybe someone has gotten significantly ill or disabled and no longer able to care for children, or has succumbed to an addiction problem that would make them a very poor choice. So there are no guarantees. And once you're no longer here, you no longer have any legal rights to enforce things. So it's best about communication and collaboration with your spouse on what will happen. Okay, guardians. So how do you decide? What is this process like? So we're going to go through 4 steps here. And again, don't worry about taking detailed notes. All of this is going to come in a document that I'll share with you towards the end, going through all of these steps for you. It's likely a process that you're not going to decide right here, right now. It's likely a process that you'll need some time and space to reflect upon. You'll need to discuss with your partner or your other half, whether you are still together and parenting in one household or co-parenting. There are still couples who no longer live together but are excellent co-parents. And what I encourage people who are couples and who are parents together and have that communicative relationship is that you each create your own list for the next few steps. And then you want to come together and compare and to see how those lists overlap and to have a good discussion point. And I often talk about being a life and legacy planning attorney, because I find these discussions for parents are so helpful, not for if something happens to them, although it works for them, but it's so important for right here and right now, because you start to realize what are the values that are important to you and really discuss your parenting styles and sort of some longer term visions and ideas about how you want to raise your children. So this is a worthwhile discussion, even as you co-parent together. So the first step is you just want to get out some paper and do a brainstorm of creating your short list. Who are those people in your life that could possibly be guardians for your children? It can be siblings, it can be parents, friends, aunts and uncles, cousins, godparents, nieces and nephews, college roommates, lifelong friends. Remember, the goal here is that anyone is probably better than foster care, right? If you don't name someone or come forward, there's a chance that at some point, we'll talk about this in terms of long-term and short-term guardians, that children could be put into a foster care system or child protective services while the courts sort things out. So the easier we can make things on the court process ahead of time, the better. So even though we'll have to go through that at some point, if we're more organized and present your wishes and well documented, it's going to be a much smoother process than trying to figure things out from scratch. Mistake number one, I told you we're going to get through some mistakes here, is considering finances when choosing a legal guardian. One thing I don't want you to do is when you're thinking about the guardian of the person, and that's what it's legally called, that's who's going to be in control of the legal decisions around your children, where they go to school, and how and make medical decisions for them, and generally raise them, right? And if you go and revert to well, which relative has the most money and is most well off, first of all, you shouldn't be placing that burden on that relative to raise your children. You should think about what are your resources, right? What are you going to be leaving your children should something happen to you? Do you have life insurance? What are the funds you're going to give to the person that you want to raise your children? So you should be responsible for making sure there's enough financial resources for your children, so that is not the driving decision. The driving decision about who raises your children is about who you feel is the best match for your children and for your desires for your children. Mistake number two is only naming one guardian. Your backup needs a backup, and that backup also needs a backup. We always name in at least threes because we don't know what will happen. And we'll talk about also about what happens if you have couples and you really only want one of those people to raise your children. And if the other person is no longer there, you might need to move on to the next one on the list. It's really important to make sure you have several layers of options. Okay, how to decide. Step number two. Now I want you to think about what are your top three parenting priorities. Keep in mind we talked about creating these lists for you and your partner to each create these lists. And this is where discussions are going to get interesting. Perhaps a little bit of a debate, right? But see where you can find overlap and compromise. And you know, is really personality for one person or really just an offshoot of parenting style. Try to find the common ground you have in pieces that may have different names, but actually may overlap more significantly than you think. And I've put a list here together, again, that is shared in the documentation provided for you at the end. It's not, I have, this list is not exhaustive. And so you can think about that for what is most important to you as well. So this is, you can add things onto this as well. Okay, I see a question in the chat and I will get to that. I will speak to that question shortly. Actually, it's on my list of things to talk about. Number 3 is you want to match your parenting priorities with your short list, right? So what are the goals? What are those key parenting priorities, and who on your short list it most matches up with that? And we want to think about this too in not about the shoulds, right? Well, I should name my older sister because, well, they're older and they know more than I do, right? We should try to move away from those shoulds. Or I should name my parents because they'd be hurt if I didn't. But sometimes your parents may not outlive you for very long, and your children would be required to move to another home, for instance. Or perhaps you're thinking of your most successful sibling, and again, based on that financial resource is driving that decision, rather than if capacity to show love is among the biggest drivers of your parenting priorities, and that doesn't match up with that sibling who's working 80 hours a week, maybe that's not the best choice for you. The other thing to think about is how you want to name couples. Sometimes you want your sister and her husband as guardians, but if something happened to your sister, while you love your brother-in-law, you don't think you would want him raising your children all by himself, for instance. So there are ways that you can designate in the guardian nomination form how to nominate couples so that they can serve jointly. If you believe that they can both serve individually, you can say that, such as serving jointly or the survivor, or serving jointly, or Jane Doe serving alone, but not John Doe serving alone, or jointly only, or serving alone. So those are options too. And that is mistake number 3 that parents make, is they named a couple as guardians, but didn't make a plan if the couple separated, if they divorced, or one died. So just because we name a couple, if you're really only interested in one of those people being the primary guardian, make sure that you state that very specifically, and that there's a backup in line. Then number 4, it seems easy now, right? Complete the guardian nomination form. Which leads us to mistake number 4, only naming guardians in your will and not taking into account if you are temporarily incapacitated to take care of your children. So another important aspect of estate planning is that we're not just planning for your death, we're planning to protect your life if you are temporarily incapacitated, so that your assets, the people you love, are able to be taken care of while you have the time to recover and engage fully back into this life. So it's not only just about your death, but perhaps more importantly in some ways, because it gets overlooked, is that if something happens to you for a short period of time and you're incapacitated, but you need someone to take over and care for those children, to make sure they get signed up for school next year, to take them to the doctors, to allow the doctors to be able to give them treatments, to authorize treatments, to sign them up for sports. All these things require a legal guardianship. And if you are, for instance, in a hospital recovering from a severe accident and not able to communicate for a while, or to handle these affairs for your children, you need to have someone else capable to do that. And if we put guardians in wills only, then that means that only operates at the time of your death. So that's why the guardian nominations that are separate and outside of your will are so important. And we make sure that wills are written to say that those guardian nominations are separate and live outside of the will and referenced in the will, should they need to be exercised in the event of your death. So that is mistake number 4, which is why what I provide today in terms of templates are so important, because they can live outside your will and operate both in times of incapacity and upon death. So some tips for completing these forms. Remember, couples also have to complete their own forms. So you don't do these jointly, you do these individually. But you should coordinate and name the same guardians, and you should always name in threes. Store it in a secure location where authorities and your guardians can find it. And we'll talk about this a little bit later on too, but it's really important that you communicate your wishes to those people, so that they know both where to find the documents and what's required of them. So you can send copies to all of your nominated guardians of the documents and tell them where the originals are, because they'll need those originals when they go to court. But having copies of them gives them immediate access if they need to show up in a very quick emergency, to show to police, to show to a school, to show to someone, to say, hey, it's okay. I've got legal authority to do this, to take care of these children right here and right now. So the communication aspect is important. Some lawyers, and it depends upon your relationship with your potential guardians. That's something you know more than lawyers. But you may want to send generalized letters to the alternates, because in some cases, the alternates feelings could be hurt that they weren't selected. That is a personal decision for you, and you know your family and what that means. And again, if you have a will or plan on executing a will, make sure your will mentions that you have executed a separate guardian nomination and nothing in the will supersedes that. To make these documents legally sound, you should sign in front of witnesses, 2 witnesses. So don't go ahead and sign it until the witnesses are there and they can declare that they've seen you sign them. An extra level of sort of legal security is a notary. Most wills are the witnesses are notarized, and that means it's a self-authenticating will, which means the witnesses do not have to show up into court to say, yes, we saw this person sign the will. It was them and they signed it. Can't guarantee that notarizing guardian nominations will allow witnesses not to testify into court, but it definitely creates a stronger possibility that those guardian nominations can also be what they call self-executing. Here is the form. I just wanted to show you a snapshot of what this form looks like. It really is just as simple as, if a guardian of the person is required for any minor child of mine, I nominate X, serving jointly, for example, or serving jointly, or the survivor of the couple to serve as guardians. And if the above nominated guardians are unwilling or unable to serve, then I nominate the individuals to serve in preferred order and not serving jointly unless so specifically noted. And it's really as simple as that. Below that are some pieces around witnesses and making sure that what we call the testator, you as the parent is the testator, signs it, make sure that your name and address and date is on that. So there's a few other legalities in terms of the statements being true. And the witnesses' signatures, but that really is the legal meat of it, shall we say. And as I talked about earlier, there's some options for nomination language. If you don't want couples, if you only want one of those persons in a couple to serve, if the other one is no longer there. So there is some potential language. If a guardian of the person is required for any minor child of mine, I nominate John Doe and Jane Doe serving jointly to serve as guardians. And if John Doe can't serve as guardian, Jane Doe to serve alone. However, if Jane Doe cannot serve as guardian, then John Doe shall not serve alone. Or if you want to name them jointly, and then either as sole guardian, there's language there, and there is simply sole guardian language as well. So those are all options you can use as you go through and naming the 3 layers and 3 levels. You can go deeper than 3 for sure, but 3 is a minimum. And this is where people get hung up. Don't get analysis paralysis. No one is better than you to raise your children, but your job is to do your best for a worst case scenario. Giving guidance to your family helps prevent unnecessary conflict, where family members will want to fight because they both believe that they're doing the best in your name. And if you tell them ahead of time what you think is best, doesn't eliminate the possibility that they will still challenge, but it certainly minimizes. I will say with all of this, and there's another question here about guarantees. There are no guarantees. What your goal and objective in doing the guardianship process is that you are giving your potential guardians as much information, as much legal backing and the legal power that is available to them to best carry out your wishes. There are no guarantees. I can't ever say that there's going to be guarantees. But as I said before, I can guarantee that if you don't do anything at all, your wishes are less likely to be preserved and followed. So also keep in mind that you can change it, especially if you keep it outside your will, and you probably will as your children grow. I will say that when people do have trusts, and I'll talk about this a little bit at the end, there's a lot less court involvement because trusts, if they are done well, are very comprehensive, have a lot of guidance and overview on that. And a judge is going to look very deferentially to that trust because so much time, thought, and legal effort has been put into creating that document that sets forth all the circumstances around how money is going to be handled and how guardianship is going to go, having medical powers of attorneys in there, and all those designations. So it's very comprehensive. So a judge is going to give a lot more deference to that. Yeah. So mistake number 5, I guess, goes also into this concept of what guarantees our wishes are followed, is you didn't exclude people who might challenge your guardian decision or whom you don't want to be guardian. So a lot of people are afraid of, when I read the word guarantee, that they're afraid that there's someone who's going to come and challenge their decision after they're gone. And so what we can also do is a confidential exclusion of guardian. And this is a review of the form and another one of the templates I've provided you, where you say that you specifically are you've executed a separate nomination of guardian. You are excluding a specific individual or individuals, and you're going to list out those reasons as to why you don't think that person is appropriate. So the more information you can give either within this form or in a separate document, a separate file, demonstrating your reasons as to why these people should not be guardians of your children, is the more ammunition, shall we say, that you can give your potential guardians to make sure that your wishes are followed. So, for those who are talking about, well, I don't want my ex-spouse, that person's never around in the child's life, I don't want that person involved. This is where you would attempt to exclude that person, particularly if you, as a parent, had sole legal and physical custody. Again, there's 2 ways that can go. The parent who did not have custody could have a life change and could all of a sudden step up to the plate and become the parent they always should have been. And that would be a win for your child. There's no doubt about that. But if not, the more information you can provide your potential guardians, that to have in a court proceeding as to why these people should not be your child's guardians, the more likelihood that the judge will consider and grant that request. Now, this is a confidential exclusion. So what you want to do is keep that in a safe place with all of your other documents. And those potential guardians only ever need to use it or see it if those individuals you have excluded try to petition the court for guardianship of your children. So this is not a type of thing that comes out and you have to have long debates with people. No, I've told you I don't want you to have my kids. This can be preserved for at the time of when there is a challenge to guardianship. And again, there are no guarantees, but the more you document, the more you state your wishes, the more you support your wishes with reason, with evidence, and give your nominated guardians places and witnesses and other evidence that they can go seek and find in support of your wishes, the more likelihood that they're going to prevail. And so it's the same as a regular guardian nomination position. So you want to store it in a secure location, communicate to your guardians that there is this document, and let them know where to find it if they need it. You don't have to tell them what's in it now. Just tell them where to find it when they need it. And if you have a will, make sure you have mention that you have executed a separate guardian nomination and a confidential exclusion, and nothing in the will supersedes it. And again, sign in front of witnesses and or notary. Mistake number 6, not naming short-term guardians who can take immediate care of your children if long-term guardians are not immediately available. This is a big gap. The babysitter may be there with your child. The police may have to come because there's been an accident and they're trying to locate people at home. Child Protective Services might become involved. And so in addition to long-term guardians, so in the packet, you'll receive a template for long-term guardians, for a confidential exclusion, and for a temporary guardian. Now, this is just people who are close to your children, who can comfort them. They live 20 minutes away. They're people your kids know, love, and trust, and they can be there right away. And you provide them with the legal documents they need. You instruct the babysitter on who to call, and you can even create an ID card in your wallet about should an EMT need to get to your wallet to find out who you are. They can see that you have kids at home or at school and they need to be picked up. And these are the people that you call immediately to go get them. Because a lot of times our long-term guardians are family members who may live in other places or who may travel a lot, or there's a lot of different reasons why your long-term guardians may take 24 hours, 48 hours, a week to get to your kids. And if you're in a serious accident and they need someone to take care of them, they may have to go into foster care while that is all being sorted out. So, these are your neighbors. These are your child's best friend's parents, right? It's people who can pick up the slack in the interim. These people are not going to be called upon for months-long guardianship or long-term guardianship. It's to fill that immediate gap, which can be a very traumatic time for children when they're not sure what has happened to their parents, either short-term or permanently. So we call this a kids protection plan when we take all of this into it together. And it's something that I work on with all of my clients who have minor kids. And it's we start out with choosing the right long-term guardians. We go through that step process of identifying the people, identifying our parenting priorities, and matching those up to find out who those choices are. We're using reason that we can tie to values and beliefs rather than relying on emotions or guilt or what you should do. That's where you legally document your choice in the documents we provide. Choose the right short-term, long-term, short-term guardians. local friends or family within 20 minutes, and legally document that choice. Number 5, this is huge. Give your short-term guardians legal documentation and instructions. So you want to give them copies of your short-term guardian nomination forms. You want to let them know, you make sure they know where the kids go to school or sort of where they might be. You can also provide medical power of attorneys in there as well. And you give that to all caregivers and schools, instructions on who to call. So those emergency forms you fill out, right? It's not just you and your spouse. Put on a couple other contacts who are also on your short-term guardian list so that they come with the paperwork that they need. Having a booklet, when we go to Airbnbs, right, we always get these binders with all the instructions of the house, right? We should be leaving these binders for caregivers, for our babysitters. So should something happen, they can go to that and they know exactly who to call and what happens next. You can carry a family emergency ID card so that it identifies you as a parent with minor children and has the phone number of your short-term guardians. And then steps 7, 8, and 9 are just as important. Number 7 is tell your long-term guardians what to do if called upon and where to find your long-term guardianship documents. Another thing that we do with our clients, and really anyone can do, is to sit down and take some time to think about giving some instructions to your long-term guardians about the things that are important and valuable to you in raising your children. How do you feel about allowance? How do you feel about limiting screen time? About the sort of extracurricular activities they should try to get involved with? What are some of the philosophies around financial savviness and learning how to earn and save? What are the things you want to pass on to your children? And you can write out a long list for your long-term guardians. And this is also where we're planning for our lives. These are such important conversations to have as co-parents, as you decide around the values that are important to you as you think about parenting. Unfortunately, so many of us get caught up in the day-to-day shuffle that we forget to step back and think about this. And this is a chance to do this, not just for when we're not here, but the kind of values and ethics and beliefs that you want to instill in your children while you are here. Number 8 is to be sure to exclude anyone you would not want to raise your children. And number 9, make sure you've got those resources through your trust, through life insurance, to make sure things are going to go to your children as you intend. Just a quick wrap up here around sort of what is left open. We've talked about, and this is why I focused on guardian nominations, because it's the most important piece to families. It's who's going to take care of your children in the short term or in the long term, if you're incapacitated or if the worst happens to you. But there's a lot more to that than this. So your default estate plan is probate. There's executor's fees, attorney's fees, appraiser's fees, bonds can be placed, creditors, filing fees, and it's slow. It's public. It's a lawsuit you file against yourself with your own money for the benefit, not of your heirs, but it's for the benefit of your creditors to make sure they get their cut before your heirs do. Last will, this is the last will of Anna Nicole Smith. Maybe hard to read on the screen, but you could search for it and find it and read it as well, because wills are public documents. Anyone can read this. That means anyone can know that your children are, what sort of inheritance they might be getting, and they can be targeted by unscrupulous people, particularly when they're young. Because if you don't do proper planning, As soon as children are 18, they're going to receive all of those assets. In the meantime, if you only have a will in place, you have guaranteed probate, and the court will oversee the money that those children will have until they are 18, unless you take different steps. So your legacy is not just about your money or your assets. It's also about the insights, values, stories, and experiences you can pass on to your children. That's why it's so important to create that lovely document for your long-term guardians about how you want your children raised. But we also do at my firm a reflection exercise and your legacy story, where you can actually share some of the stories and experiences and record those for your posterity's sake, whether you pass them on in 2 years from now or in 30 years from now. I guarantee you it'll be something very special to pass along. As I said earlier, it's called an estate plan. You saw how easy it was to create these small pieces, these documents, but they're just a small piece in the puzzle. And it's not about estate documents, it's about a plan. Because first you have to understand the law and how to use the law for the best legal outcomes for the worst situations. Two, you've got to get organized. It's not just about having the documents, but that they are organized. I've seen so many instances where people have the will, but they don't know where to find the bank accounts. Where's the deed? They don't understand how many accounts they might have. You need to get organized so that people can find these things. And three, the most important piece of this puzzle to me is communication. You've got to make sure your loved ones know your plan, they understand your plan, and they know how to execute it when the time comes. And that's really about communication. And so in my firm, we do that through helping create letters to telling people about their plan. Unfortunately, I see too many people out there who have a plan but don't really understand what it does or how it works. And to me, that's only half a plan, and that's a recipe for a plan failure. You need to know the plan, and you need to have open conversations and communications with others so that they can execute it when it is needed. Remember why you're here. It's not for you. Estate planning isn't for you. It's for your loved ones so that they know that you took care of it. And that's why I always talk about it is planning for life, a plan that will work when your family needs it. So just want to tell you about my process before we go and give you the documents. As I said, you can schedule a free family wealth planning session with me. I've put a link in there right now that goes directly to my scheduling website. And in that session, we get to talk a little bit more about wills. I'll tell you more about trusts, about what the benefits, pros and cons of each of those processes are, so that you choose the plan that works best for you. And in choosing the plan that works best for you, you get to choose your fee. My fees range between $2,500 to, at the very high end, for very complex and for very deep support, $8,000. But these all include a comprehensive kids protection plan. And we start with that family wealth planning session. Like I said, a consultation on your specific issues and your unique family circumstances. If we decide to work together, that's when we pull back into a design session. We get into the nitty-gritty to designing what your plans are to meet your goals and objectives. This whole process takes about 6 to 8 weeks. And at the end, we have a signing ceremony where we deliver all the documents, explain them to you, have all of the letters ready for you to share with all of your fiduciaries and your guardians, anyone who you've nominated to participate in this process. And then we follow that up with a binder delivery meeting where we have all of that information in one spot that's easy to access. Your assets are organized. It's easy to understand. And we give you, also we can arrange family meetings so we can help explain it to your loved ones. I think that is it. We create a personalized plan for your loved ones, capturing your family wealth and going home with peace of mind. As I said, you can schedule my session there. I'm going to share with you the files. Thank you for sitting with me through this. Any other questions? There is the instructions sheet. It is in PDF format. And there is the templates for the 3 templates for long-term guardian, for confidential exclusion of guardian, and for your short-term guardian. Those are all in Word documents, so they are completely editable. You can edit them as you desire. And again, the instructions will have some tips for you on how to complete those, particularly around the options for choosing languages around couples, if you wanted to serve jointly, or in case you only want one of them to serve, if the other one it does not survive. I would like to thank you for attending, and please feel free to reach out and schedule some time with me. I've got my phone number on the screen, my email address, my website, and there's also a link in some of the materials, again, to register and take advantage of the free consultation session. So I can give you some more personalized advice and see if there's something you want to work on deeper with me. So thank you again, and all the best to you.